Mr. Kenny, Mr. Berry, just before we start, just to demonstrate that I've been paying close attention to the submissions. This morning, a different constitution of this court, where I wrote the lead judgment, handed down a judgment about the measure of loss in particular circumstances involving defective buildings. One of the cases that we were referred to was a case called the London Corporation, and you can find that in the probate report 1935, page 70. The only reason for referring to it, and I've referred to it today because we handed down the judgment today. The judgment today is not material, but it refers to the case. The only reason for referring to it is that it's a case about a ship, so you're both excited about that. It was a ship that was damaged. The claim was for the cost of repair. The defendant said, well, look, the claimant actually has sold the ship to be broken up, so therefore we shouldn't have to pay the cost of repair. And the court said, no, you're liable for the cost of repair. Two things. Firstly, it was Lord Justice Greer. Obviously, I've come to know and love as a result of this case, but I had not remembered that it was him in this case. But also, he uses the expression, the fact that a vessel has been sold to be broken up is an accidental circumstance not to be taken into account in the way of diminution of damages. So I simply draw that to your attention, and I've given you the reference. The best thing is if either of you want to make 3-paragraph submissions about it in relation to the rest of and how, if at all, it's of any relevance, then you're very welcome to do so. Where are we now? Wednesday lunchtime. Whilst it's all fresh in your minds, if you wanted to do that by the close of business on Friday, then that would be good. But it may well be of no relevance at all, but I wouldn't be doing my duty if I didn't draw that to your attention. So it's 1935 probate reports, page 70. As I say, demonstrating that not just my lord and my lady who have been following this case with close interest. So, Mr. Kenny, having given you the short adjournment in order to refine your submissions in reply, you have 4 points.
I have a couple more than 4.
Right.
But I will be half an hour.
Fine. When you go through them, if for the sake of my boring note, you could tell me when we're moving from the first to the second and so on, that would be good.
I'll be as clear as I can. Yeah. All right. I'm going to start by risking revealing what a bonehead I am, because I just want to be clear that we've got it all right about the extremely simple solutions that the Charter has offered to the cases that we said were problematic. So if I can just recap where we've got to. The first of those was the case where the owner fixes the ship forward. So just imagine the case that the owner fixes the ship a couple of weeks in advance of the contractual redelivery at $80 a day, but by the time the contractual date of redelivery comes around, the market rate is $100 a day. Which rate do we take? Answer, the lower rate, because the lower forward rate defines the owner's actual loss. And we just have to take on the chin that...
So is this his answer or your answer?
This is his answer.
His answer, right? Okay.
This is his answer.
Yep.
All right, and this is with a view perhaps to testing the idea that this is all extremely simple on his and the judge's view. So, from the perspective of the charterer, I mean, the first thing that reveals is it does absolutely matter what actual arrangements the charterer has made, because it's going to be a defence for the charterer to demonstrate that whatever the normal measure might provide, the absolutely routine circumstance that the owner has fixed his ship forward may provide him with a defence because he can demonstrate that the actual loss was lower. In the converse case, in other words, the owner fixes forward at 120, but the market rate come the contractual redelivery date is 100, the charterer will, of course, be able to say, the late redelivering charterer will be able to say, well, I don't care what your forward rate is, I'm chopping you down by reference to the normal measure to the rate at the contractual redelivery date. But that does leave us with the perplexing philosophical question, why do parties contemplate the rate at a date when the owners would never in practice actually fix the ship? This is supposed to be an estimation of income.
Because that's the date of the breach.
That's the date of the breach, not the date of the date at which the revenue earning fixture would in fact have been made. I mean, as my Lord Justice Mail said, owners do in practice fix forward. Of course they do, because you've got to have your employment lined up. So, either way round, inevitably we're going to look in detail at the actual arrangements made. And certainly when the forward rate is higher than the rate at the date of breach, do you have this very odd situation where the parties have contemplated a loss that's never in practice going to arise, to the exclusion of the actual loss. Okay, secondly, the extremely simple case of the dry dock. At the contractual redelivery date, the market is 80. At the end of the dry docking, that we assume does in fact take place, the rate is 100. Which rate does the owner get?
I think Mr. Berry says 100.
He says 100. Yeah, he says it's the dry dock rate.
Or 80, I don't care.
But which dry docking date? Is it the rateably extended projected dry docking date, end of dry docking date, or is it the actual end of dry docking date? Mr. Berry says, well, it's the actual end of dry docking date, unless the delay during dry docking constituted a break in the chain of causation. So the extremely simple procedure for estimating what the end of dry docking date that gives us our rate of our rate for calculating damages is to work out what the expected end of dry docking date was, determine what the actual end of dry docking date was, determine the reasons why the actual was not coincident with the projected, and then determine whether any of those reasons constitute a break in the chain of causation. Okay, but final extremely simple solution, positioning voyage. The answer to this is, all you do is, you work out the time charter equivalent for the ship's whole next employment. All right, so we've got to look at what the ship, not only the cost of the ballast voyage, but the profit and loss on the next trip or voyage charter the ship may have performed, so that we can work out a time charter equivalent rate across the whole period, including the ballast voyage. And then we compare the time charter equivalent rate with the market rate at the time of redelivery and select the lower figure. my submission about all of that is, if as Mr. Berry suggests, LMAA arbitrators do their business in their sleep, they are capable of embracing considerably more complicated and difficult and problematic calculations than anyone who has read the normal measure would have understood that normal measure to entail.
Or in a word, you say it would give them nightmares.
Exactly.
Which is a jolly good reason for why you ought to have liquidated damages. Then you wouldn't have all of these hypothetical causation difficulties. When a building's late, you get all of those problems, but it's never a problem because the parties have agreed beforehand what the rate is.
Yeah. My lord.
Instead, therefore, there's a question of whether this applies automatically, regardless of loss or not. That's the issue.
Yeah, my lord, can I just say on that the normal measure, as we propose it, it is as close to an index-linked liquidated damages clause as you could possibly get.
I follow that, and so that's why I say the issue is there an automatic entitlement to that?
Yeah, to which we say yes.
Yeah, I understand, but that's the issue for us.
Okay, my lord, second point. This is the second point is the Charterer's golden rule. And the golden rule that has been distilled for you from all those cases is that the MOAs in this case can't be excluded from account because the law always brings into account subcontracts for the sale or resale of the self-same goods. Now, in answer to that, I'm going to give you what the charters might describe as a nihilist's manifesto. And there are 2 points to that. The first is, in remoteness, viewing the matter from the perspective, through the lens of remoteness, there is no such rule. What is or is not too remote depends on what would have been within the contemplation of the parties at the time of contracting. Alternatively, viewing the matter through the lens of res inter alias acta or of causation, the rule is that the subcontract will be taken into account if it's sufficiently connected with, causally connected with, the original contract, but not if it's collateral or an independent transaction. And the sale cases that you've been asked to look at offer you no refinement on those two simple principles. What about the cases? Very briefly, Rokanaki, unless it can be explained away as an application of the Sanix Ace principle, it is against the Charterer's golden rule. Agios is against the Charterer's golden rule, and I remind you of Lord Dunedin's response at 96 that I showed you yesterday, where he says the claimants are in a dilemma. Either this was a contract for the sale of different goods, in which case the sale is irrelevant, or it's a contract for the same goods, in which case it's irrelevant, on different reasons. Thirdly, the New Flamenco is against.
Sorry, the which case?
The New Flamenco.
Oh, yeah.
This is the case that I didn't take you to, but it's a case of a repudiated charter where the owner sells the ship afterwards. The reality is, the New Flamenco is very close to the facts of this case. It's breach of charter, followed by sale of the ship. The sale of the ship is said to extinguish the loss on the breach of charter. And the Supreme Court said, no, the sale is not sufficiently connected to the charter transaction for its economic effects to be brought into account in the calculation of the damages recoverable in the charter party claim. So there are three cases against, and I'm afraid only two of them are the House of Lords or Supreme Court. One of them is merely a case decision of the Court of Appeal. What are the cases in favour of the Charter's golden rule? There are essentially two cases that the Charterers rest on. One is Patrick and Russo British, which was the case that was produced overnight. And we simply say about that, well, just read the head note, because it says that in that case, the parties to the sale contract had the resale in contemplation. In other words, it's just a sort of straightforward application of second limb of Hadley and Baxendale. The parties, at the time of contracting, contemplated the resale which founds the claimant's loss. The second was Wertheim. And whether Wertheim is right or wrong, I won't detain you by giving you my personal testament of why I happen to think it's right and it's not. I think whether it's right or wrong, for the reasons that I explained yesterday, a hiring contract under which the hirer doesn't get the agreed allocation of time is not like late delivery of goods. It's like non-delivery of goods. And I spent some time on this yesterday, but I'll just give you a very simple example to test this. Imagine that you agree to hire my holiday cabin for 7 days over half term. When the first day of the hiring arrives, you arrive looking forward to your eager holiday, and I say, sorry, the cabin's not available. And I keep telling you it's not available for the first 6 days of your holiday. And on the 7th day, I say, okay, you can have the cabin for a day. Have I failed to deliver the use of the cabin, or have I just delivered it late? The answer is I failed to deliver 6/7 of what I promised to give you. So Wertheim has no application because the consideration, which was property and the goods, was delivered. It was delivered late. In our case, the consideration, at least the promise, was to restore us the use of the ship on the last redelivery date, but we just didn't get that use at all for 2 and 7 days, and that's a non-delivery of use. That is a loss of we were finally and irreversibly deprived of the use of the ship for that period of time during which, as per our contract, we should have had it. It's not a transfer of title, which can take place at one time or another. It's a transfer of use, which on any particular day either happens or doesn't happen. So Wertheim, we just say, it's just irrelevant to the proper analysis of the present case, because it wasn't a hiring contract. Third point, Rudakanaki. This only shows the sad progression by which one goes from nihilism to baby murder, because having been nihilistic on the last point, I've now thrown out the baby with the bathwater, it was said. with respect to Rodokanaki, I just want to repeat that we don't seek to extract from it any principle about the circumstances in which a sale of the subject goods is or is not too remote. We're nihilists. We don't do the transfer of remoteness decisions from one context to another. All I seek to extract from it is the conclusion that the application of rules of remoteness may both reduce and enlarge the claimant's damages. Right? That's the only principle we get from it. We don't, the particular detail of whether Rodokanaki happened to be a case which is consistent with subsequent cases or inconsistent doesn't matter. It's the Court of Appeal saying these circumstances, the subsale, were too remote to be brought into account, with the effect that the claimant's recovery was larger than it would have been if the circumstances had been brought into account. As regards Mr. Berry's suggestion that Rodokanaki is actually a case in the Sanix A-slide authorities, that may be one to be taken up another time, but the striking feature of Rodokanaki is that it wasn't reasoned in that way. I mean, it's just to ex post facto completely re-reason the decision. Okay, my Lord, fourth point.
Yeah.
The fallacy in the charterer's analysis of the case law is that it all founds on treating cases about goods that were replaceable in the market as if they revealed principles that could be applied in a case where the agreed service could not have been replaced in the market. So in all the there's a market sale of goods cases, if there's non-delivery, the buyer is expected and presumed to go into the market to replace what was not provided to him. And that replacement use of the market for the purpose of replacing performance not delivered does arise in the charge party context. It's the Elena D'Amico. The Elena D'Amico is you were supposed to be chartering my ship, you've thrown up the charter, I can go into the market and find a replacement charter, and then the price of the rate I achieve under the replacement charter defines my loss. But in the case of late redelivery, the first and obvious fact is we can't replace what has not been delivered to us. Right? Nobody was there with an empty ship willing to charter it to us for 2 or 7 days. And indeed, the nature of the business was we couldn't possibly have made use of a ship for 2 or 7 days. It's unreal to treat the present case as if it could be regarded as analogous to the case where goods or services are available by way of replacement in the market.
Mr. Berry, of course, uses that as a stick to beat you with. He says, well, precisely, there may be cases where you could replace in the market, and those are the cases in which you ignore the subcontract.
Sorry, there may be cases where you can't replace in the market, and that's where you ignore the subcontract.
Could.
No, could. That's his whole point. His point is, if you could, as I understand it, and he's nodded at me, so I think I've got the point.
That's not carte blanche, really.
That if the goods are replaceable in the open market, you
Yeah.
expect the person concerned to go out and replace them.
Yeah.
And it's in those circumstances that you get the market rate and you ignore the subcontracts as being res inter alia acta or whatever label you want to put on it, too remote. But if you can't, he says, then that's the very reason that you don't ignore the subcontract.
Yeah, that is as we described it in the skeleton, the Elena D'Amico basis for ignoring a subsequent contract. That is, well, it doesn't matter what my subcontract or third-party contract provides, because I can put myself in a position to perform that as I like by going into the market. But there are two other reasons why a subcontract, to use that term loosely, may be irrelevant. The first is that it's too remote. All right, the various analysis, as you've just summarised it, is a causation analysis. It's the Elena D'Amico principle, and it has nothing to do with remoteness. And we say, no, we found on remoteness. And secondly, it is a causation logic or principle which is often labelled res inter alia acta, but it's a different causation analysis or res inter alia acta analysis from the one that I offered you as point 2 of my nihilist manifesto, viz. the causation analysis in the New Flamenco or in the Doric Valor, which is that it's an independent transaction and so unconnected with the charter party as not to be fairly brought into account in determining our loss flowing from the charter party. So the answer is yes, you're right. The unavailability of a replacement in the market might found one or might displace one circumstance in which a subcontract was ignored, but it's nothing to the point for the two principles that we actually rely on. Okay, so coming back to my point, late redelivery, irreplaceable in the market, and I then just simply say, or pose the rhetorical question, what is the function of the chartering market in this case? And the answer is depending on whether you accept owners or charter's case, either valuing the services that we didn't get, or as Mr. Berry would have it, helping you to estimate the earnings that the owners might have made. And for both of those purposes, it doesn't matter whether the market's available or not. I mean, in any real sense, the market wasn't available because they were using our ship. All you're doing is you're using the market as a yardstick for placing a value on what we didn't get, whether by way of services, as we say, or earnings, as they say.
Or thirdly, or is this the same as your first way of putting it, a reasonable sum for their use of the ship?
Yes, yes. So, I mean,
Is that what you mean by your first thing, or is that something different? Valuing the services you didn't get.
Valuing the services that we didn't get, applying the normal loss justification for the normal measure of damages, valuing the services that they unlawfully took, taking the user damages approach.
Well, another way of looking at it, Mr. Kenny, is a fairly simplistic way of looking at it, is they've had the ship for longer than they would otherwise have had it.
Yes.
they're entitled to keep it, and you're obliged to treat it as under the charter, but you're not obliged to give them that ship at the same rate as you agree contractually. So somebody has to work out what you might have charged them for the use of it for the extra 2 or 3 days.
Yeah.
And that's why you look at the market, because it's what you would have charged somebody else if they'd wanted the ship for the extra 2 days. The fact that you've sold the ship is neither here nor there.
Yes.
Is that a simple and fair way of looking at it?
Yes. Can I say that what you have just said is what we would have charged them, or a reasonable rate, it is the measure of damages for user damages. In user damages, the measure of damages that the law provides is the reasonable rate for the user unlawfully taken. The other context in which you look at the reasonable rate for the service actually provided is implied contract and Stevens and Bromley. And I'll come on to that in 1 minute.
May I just interject here, because my learned friend argued those 2 things before the judge, lost, and did not get permission to appeal.
Yeah, I think we're aware of that.
And he is trying, in my submission, take advantage of a very probing question from my lady to revive an argument that is not open to him, which is a reasonable sum for the use that my client arrogated. Not open.
I'm not asking you, of course, to find that the tribunal were right to say that we could recover under an implied contract in this case. But I am, because it's going to be a point that I'm going to come back to in answer to one of the points Mr. Board made, I'm going to say that the measure that my lady has just suggested as a possible way of viewing the loss here, it is precisely the measure that the law provides as the measure of loss or the measure of recovery for user damages. And it's also exactly the measure that the law provides in a case of implied contract, where that is made out. But coming back to my Lord Justice Mayle's
in that case, I should tell you, your ladyship, what our answer to that was, which is, if that be right, it's not the market rate. It is the supposedly rate that would be negotiated, which was nil. And our submission below, against which my learned friend, well, there's no leave to appeal, is that if the owner had if we'd gone to the owner and said, what do you charge us for 2 more days? Or the owner had come to us, the owner said market rate, we would have said, well, what are you going to do with the ship? The owner says, immediately sell it to the MOA. We'd have said, in that case, you can't get the market rate, you can't get anything. In fact, we're giving you a bonus by paying higher, and the negotiated rate would be nil.
But the test is not what rate would the parties have negotiated. The test is what is a reasonable rate for the service provided. But I mean, let's not get dragged into this. Coming back, my Lord Justice Minas, to your question, it's valuing the services. That is, of course, you repeated myself endlessly. That is the alternative normal damages as compensation for your normal loss. Our normal loss is that we should have had the services of the ship for the 7 or 2 days. And the normal measure of damages for a normal loss, see the passages from McGregor, is the value of the services we should have had. A reasonable value for the services we should have had. Now, that again coincides with the reasonable charge for the non-contractual services provided, which is the user damages, which is why it doesn't matter to us whether you rationalise the normal measure of loss for late redelivery of a time charter as being the normal measure of damages for our normal loss, in McGregor's language, or as user damages entitling us to a reasonable charge for the non-contractual services provided. But either way, the figure is the same, and we just sweep it up perhaps too cursorily by saying it's compensating us for the loss of services.
Speaking personally, I'm bound to say I thoroughly dislike the expression normal loss. I notice that it doesn't seem to be endorsed in the authorities, and to talk in the same sentence as McGregor does about normal loss and normal measure of loss, it seems to me to be a recipe for wholly unnecessary confusion.
The terminology, you recall that it's a proposed modernization of the old-fashioned terminology of general damages and special damages. Or
Yes,
Except it isn't really, because in lots of cases special damages are the things you can put money on, and the general damages are just the claim for inconvenience or what have you. I think what he's trying to do is to modernise and make more explicable the first and the second limbs of Hadley and Baxendale. But one can talk about, well, usually in these circumstances, the measure of loss is, one understands that. I think it's just a semantic point.
For my purposes, all I need to persuade you of is that we suffer a compensable loss when we contract for services which are not provided, even if we don't suffer a pecuniary detriment. And the great example that he gives is, I contract for a violin lesson with Yehudi Menuhin, and I get a violin lesson from some, and I get in fact some hack. It may be that I'm not in. All right, whoever is the latest, a singing lesson with Anna Trebenko. I mustn't get myself into difficulty. Netrebko. And I have a singing lesson instead with Mr. Berry.
You could sue for damages for that.
I may be in no worse financial position, but I feel shortchanged, and I want the difference in the value between the services proffered and those provided. And if that proposition, however you style it, or whatever label you attach to it, is correct, then that is sufficient for the purposes of saying I've suffered a compensable loss, the value of which is assessed by the long-established normal measure of loss for late redelivery under a time charter.
Or if you just go back to straightforward Hadley and Baxendale principles, you could say, what is the type of loss that you would have in the reasonable contemplation of the parties, to use Lord Hoffman's Agios, subject to them taking on the risk of that happening. Yeah. And the answer is it's the market rate at the date of redelivery.
Yes, I mean
the date of breach.
My only hesitation about coming to that is that once you start to say what are the readily foreseeable consequences of redelivering late, all sorts of things, as was recognised in Agios, may come into the picture, such as loss of income, such as missing an MOA or a dry docking. And all of those may crowd into the first limb of Hadley and Baxendale as readily foreseeable consequences. And what the House of Lords has done is to say, by applying another metric of assumption of risk, I'm reducing the heads of loss within that first limb to whatever is covered by the normal measure of loss. And what is covered by the normal measure of loss is... Okay, so I was on... my
Number
point
4.
4, which was the fallacy is replaceable and irreplaceable, I come on to point 5, which is joiner, and the article by
Jonathan
Gaunt. And I just, it may not be much to the point, but I just clarify one, what, at least as I understand it, Mr. Gaunt is actually saying. What we rely on Joiner and Weeks for is that the next business contract was left out of account and treated as res inter alis acta, or perhaps, as we put it, too remote to be taken into account. What Gaunt is talking about is how you measure the owner's loss before you take account of the next tenancy. All right, so he's not complaining about leaving the next tenancy out of account. That's not the complaint. That's not the aspect of the law brought about by Joiner and Weeks that he says is all wrong. He doesn't refer to that at all. In fact, that's taken, I understand, is taken for granted as right. What he's actually focusing on is a different point, which is that in the divisional court, they said, we're leaving out of account the next tenancy, but the value of the owner's loss is the depreciation to the reversion, whereas in the Court of Appeal they said, no, they agreed, leave the next tenancy out of account, but they said the value of the owner's loss is the cost of rectification. In other words, what he's focusing on is the difference that was the subject of Ruxy Electronics, i.e., my house is £10 less valuable, but it'll cost £50,000 to rectify my swimming pool. And that's what he's complaining about. What he's not saying is, oh, the Court of Appeal were wrong to exclude the effect of the next tenancy. And the whole proposed solution is that you've got to use an expert to value the impact of the breach on the reversion, not that you should be taking into account the impact of the next tenancy. Okay, I come on to my sixth point, which is Mr. Board's point. He says, with reference to user damages, well, it's very curious because if owners were right about this, that the normal measure of damages for late redelivery is a form of user damages, you would expect to see user damages claims for other kinds of time charter breach. Because surely delivering late is not the only time that you unlawfully use a ship, or might unlawfully use a ship during a time charter. And the answer is, well, of course, unlawful use in breach of a time charter, in most cases, gives rise to harms which attract a contractual indemnity. So when I unlawfully use your ship by loading dynamite and the dynamite goes off, there are harms, costs to me of repair or costs of unloading, and that's just compensable in damages in the ordinary way. What user
What if it doesn't?
Yeah, that's okay. So let me say. So what user damages is relevant for is the case when you use my ship in a non-contractual way and it doesn't cause a harm. That's where user damages come into play, just like in this case. And the answer is that those cases have always, until now, been covered by implied contract. That's the Stevens and Bromley case, right? Stevens and Bromley is the classic unlawful user of the ship without causing harm. Because what happened in Stevens and Bromley was the owners agreed with the charterers a rate of 10 shillings or whatever it was for loading steel billets. And then they loaded a cargo of general cargo, which if they negotiated for general cargo, they would have to pay 15 shillings for. And the court said in Stevens and Bromley, well, you've got to pay the market rate for the general cargo that you actually loaded, and they rationalised that conclusion in terms of an implied contract.
That's the point.
Now, in our case, we put our case on the basis of implied contract, and the tribunal said, yeah, you're right, you succeed. Now, Ms. Justice Bright overturned the tribunal on that point. As far as we can see, I mean, this is all his, by the by, on essentially the same logic as he rejected our claim that there'd been unlawful user. He said it was all covered by the charter party. But that doesn't matter. But it doesn't matter whether he's right or wrong about that now. That's not under this appeal. But the answer to Mr. Board's point is the idea of unlawful use without harm does arise all the time in, well, not all the time, but not uncommonly in the context of charter party cases. The outcome is always that the charterer has to pay for his unlawful use at the market rate. It's just that that conclusion is, in other contexts, rationalised by way of implied contract.
But if that's the rationale, that's a rationale which, because of the peculiarities of the Arbitration Act, is not open to you or us. If the basis on which you ought to have won in the court below is implied contract, but you quantum merit, but you lost, and there is no permission to appeal, we can't do anything about that, can we?
You're absolutely right. If the only way in which we could win was implied contract, and the way this has progressed is, and you're against us on damages, then we would be facing a hard position owing to the way in which the Arbitration Act is constructed. But in fact, in front of the arbitrators, we succeeded on both bases. Right? And it was not, the arbitrator's conclusion was not, you succeed on implied contract. Alternatively, if we're wrong about that, then you succeed on damages. Their conclusion was you can succeed either way. And that just means there are two rationalizations for the conclusion. And
You'll start with one of them.
And we have to make good one of them, which we seek to do in this court. I will say on this point that what could be said against the arbitrator's conclusion is that nobody has ever explained the damages, and they are always described as damages, for late redelivery on the normal measure as being paid at payment of a revised hire under an implied contract. All right? I mean, you've got 10 cases there, and none of them contains the proposition that the paragon doesn't say it's well recognised that the implied contract that arises on late redelivery calls for. I say that in that completely sweeping way. There is in fact one case where Denning says it's either implied contract or damages. It's in the Dione. He says it's one or the other, but the other 9 just describe them as damages. So if you were to hold that the claim should have succeeded in implied contract and must fail in damages, you would be overturning the unbroken succession of dictum remarked upon by Lord Hoffman. He said, everyone in the market has always understood that the damages for late redelivery are established on the following basis. my next point, my lord. At this point, I've lost track of my numbering.
There were 7, and this was number 7.
6 and 7, as they say.
I'm able, in the light of the way these progressions think, to tell you that there are 9. Mr. Board's next point was that user damages are only available, or should only be available, where there's an infringement of property rights in the strict sense, and it's not sufficient that there has been a breach of a contractual right of user. Okay, now we make two points in response to that. The first is that the breach consisting in late redelivery has a very material impact on our property. Right? The ship is our property, and the breach has the result that our ship is not where we would have it and full of their cargo. So it's not like this is a sort of a purely abstract or intangible effect. It may not be proprietary by way of legal classification, but it has a big impact akin to an interference with our property in the proprietary sense, in as much as their stuff is on board our ship. The second is, if you accept that it's very closely analogous to an interference with our property, there would be retrograde consequences to not applying the same rule in analogous cases. Right? Our submission is, okay, it doesn't matter whether strictly it's a trespass or not a trespass, in substance it's wrongful use and the same rules should apply. If you say, no, it matters whether in a strict sense it's proprietary or not, there will be many cases where owners have to arbitrage that distinction. And owners will be conscious that if they terminate, then the continued use of the ship by the charterers becomes a trespass. So there'll be a premium on termination. Right? In this case, what we might have done, if you were to accept Mr. Board's submission, is we would say, on the redelivery date, right, we're terminating. So now you're trespassing, so now we're going to get damages based on user damage and the advantageous consequences of that. And that is altogether a more chaotic world than parties continuing to operate under a contract and rather than putting themselves in the position, seeking after legal advantage based on legal distinctions which have no real world justification. I will also just add, by way of a clarification, Mr. Board took you to Lord Reed's summary of principles on user damages at page 688.
Paragraph 95.
Yeah, and you recall that he says at subparagraph 9, generally in contract cases, when it's pure economic loss, if you can't establish pure economic loss, no remedy. And Mr. Board suggested or showed that to you in a way that was like to lead you to understand it to mean, or invited you to understand it to mean, that was somehow cutting down his first principle about, Lord Reed's first principle about user damages. But if you appreciate that that list is a summary of what he said before, actually what subparagraph 9 is doing is referring back to another passage in his summary of the law, i.e. paragraph in particular, paragraph 39, where he talks about Ruxy Electronics and the availability of of compensation for non-economic loss in contract. So this is perhaps a long and involved way of saying, do not understand subparagraph 9 of the summary list as intended to qualify or cut down subparagraph 1, which is summary of user damages. Look back at the context, look back at what is being summarized, and you can see that actually subparagraph 9 is summarizing some other part of his exposition of the law of damages. Okay, point 8. It's said that we get no user damages because the use of the ship was of no value to us because we contracted to transfer that use immediately to MSC and Minsk. And he said, well, it's like Lord Halsbury's chair if Lord Halsbury had elected or undertaken not to sit in it. But that's the whole point of Lord Halsbury's chair and the passage, the reference to Lord Halsbury's chair, that what they say in the Mediana is, it's no defence for the wrongful user to demonstrate that I would not have sat in my chair or that I had plenty of other chairs. In other words, it's no defence to prove that the use of my chair is of no value to me. The damages in a user damage case are the value of the unlawful user abstracted by the wrongdoer. All right, so you don't need to look at what the use of our ship was of value to us for the purpose of user damages. It's what the reasonable price, the reasonable value to be given to the user that they had. And just to, therefore, to take this opportunity to respond to Mr. Berry's account of the negotiation that might have taken place, although it's not in fact a negotiation that the law applies, of course we would have said, well, we'll charge you $1 billion because all your cargo is on board our ship and you've got no other way of distributing it to your customers. So just as Mr. Berry says, he would have taken an extreme position, there was an equally extreme position open to us. The law's approach is to fix a reasonable price for the user that they arrogated to themselves. All right, that takes me to my last point, which is the answer that was proposed to our suggestion, our submission, that remoteness is a two-edged sword. And Mr. Berry said, I'm amazed. I mean, he didn't use these words, but he said, I'm amazed I'm having to talk about this because it's just absolutely contract, the Americans would say contract 101, that remoteness is a one-way principle. It's such a fundamental principle, we should all recognize it. And, but having been forced to show you some justification for that conclusion, the justification he chooses to show you is an article by Trifle from 1997, and the particular passage that he chooses to show you is, let's just remind ourselves, that 781, the bundle. So it's where the barring is in this article. And this is the passage that demonstrates the proposition that remoteness is a one-way street or a single-edged sword. For example, one has to ask what the injured party. One has to ask first what the injured party has lost, and then for how much, if any part, of that loss you can recover damages. Under rules of remoteness, the answer to the second question depends on reasonable contemplation. That two-step approach, for people who have followed subsequent developments of the law, calls to mind Lord Hoffman's speech in the Agios. And if you turn in the bundle you've still got open back to 533, Lord Hoffman could almost be describing Professor Tritle when he says at paragraph 14, the owner said that the starting point was that damages were designed to put the innocent party, so far as it was possible, in the position as if the contract had been performed, Robinson Harwood. I said in South Australia Management, I think that's the wrong place to begin. Before one can consider the principle on which one should calculate the damages to which the plaintiff is entitled to as compensation for loss, it's necessary to decide what kind of loss he's entitled to compensation for. In other words, one must decide first whether the loss for which compensation is sought is a kind or type for which the contract breaker ought fairly to have accepted responsibility. In other words, you've got to decide what the facts are that can be taken into account before you can ascertain what the loss is. And that point comes out again in paragraph 18 of Lord Hoffman's speech and his reference to Robert Goff's decision in the Agios, where it said, the emphasis is upon what a reasonable person would have considered to be the extent of his responsibility. The test appears to be, have the facts in question come to the defendant's knowledge in such circumstances that a reasonable person in the shoes of the defendant would, if he'd considered the matter at the time of making the contract, have contemplated that in the event of a breach by him, such facts were to be taken into account when considering his responsibility for loss suffered by the plaintiff as a result of such breach. And what we say about that and its application to this case is, you've got to resolve the question of what facts or matters or circumstances are sufficiently proximate to be taken into account for the purposes of determining the claimant's loss, and then you work out what the loss is to which we are entitled to recover. And that approach of dealing with the facts that are relevant to the inquiry before ascertaining the loss explains or underlies those dicta that we showed you from Devlin in Biggin and Permanite and from Mr. Justice Carr in the Lilly Primer. What they're considering is, in the ordinary case, you consider first the matters within the party's contemplation, leaving the peculiar and the accidental out of account. In the special case, you consider whether the parties have knowledge of special or peculiar circumstances. And on the basis of what facts or circumstances, whether within the first branch or the second branch, are admissible, you then determine what the loss is. And we just say, if it were otherwise, there would be some surprising results in cases like Victoria Laundry.
You then decide what the recoverable loss is.
Yeah, so you decide what the facts are that are
What the
relevant.
recoverable loss is.
Yes.
You're not looking at what was in the contemplation of the parties and then the peculiar circumstances. You're not doing that as an academic exercise. You're doing that in order so that you can then go on and say, therefore the recoverable loss is X.
Exactly.
So it's recoverable. It's not an abstract loss.
Exactly.
And before you do any of that, you have to look at causation.
Exactly.
Because causation is part of liability.
Yes.
So you I mean, all of that's very interesting, but causation comes first.
Causation comes first, and indeed we therefore accept that logically on what you've just said, the res inter alia acta, collateral transaction, new flamenco case comes first before the remoteness case, because if, for example, the MOAs don't have a sufficient causal connection to be brought into account, that is an answer before you say, but also the MOAs weren't contemplated. But whether the strict time sequence matters, you have to, is perhaps for practical purposes not important. What you have to do is decide what are the relevant facts for the purposes of ascertaining the claimant's recoverable loss, and then determine what the loss is.
Or as you said, I think practically the first thing you said when you stood up yesterday, you have to decide for what is it that the owners are being compensated by an award of damages for late redelivery.
Yes, exactly. And I mean, maybe they need to gild the lily by pointing this out, but if I were wrong about the submission I've just made, you could have very odd results in a case like the Victoria Laundry case, which is boilers supplied for the purposes of very special contracts, uncontemplated contracts, dying contracts, I think for the French army. And the Court of Appeal says, well, those very special contracts were not within the contemplation of the parties, and particularly the boiler supplier. But if we were not right that you decide first whether the circumstances are within the contemplation of the parties and therefore apt to be brought into account, you would have to work out what the profits and losses on those very special contracts were. And if there was a loss-making contract, it would be brought into account, and if it were a profit-making contract, it would be left out of account. That just seems a mad way to approach the assessment of damages. Mr. Berry would say, two contracts, one for the German army, loss-making, one for the French army, profit-making. Well, we exclude the French one because that wasn't a contemplated form of loss, not being able to go. But the German army that would have been loss-making, which therefore, the fact you didn't perform it actually brings about, oh, well, we bring that into account. It's another version of my MOS.
That's actual law.
Anyway, the answer from my right is, yeah, but what about the loss? This is going to end up with these owners, if owners are right, recovering more than their, or being in a better position than they would have been if the contracts had not been breached. And the short answer to that is the one you've already looked at in context. It's Slater, page 126 in the bundle, where Lord Justice Scruton says, and I appreciate you will have looked at this yesterday, and he says, it is true that on these principles, the plaintiff may recover more than an indemnity. English law frequently gives him less than his real loss. So in the case of Horn and Midland Railway, Soulson, he sometimes recovers more than his real loss. Plaintiffs in Salford Corporation recovered their real damage twice. The rules of English law don't always give an exact indemnity, and in this case they do not. Same is true in our case.
So that's the answer to the windfall point.
Precisely. My lords, my estimate of half an hour was woefully inaccurate.
No, we were asking you questions, so that's completely fine.
May I just answer two questions that my lord asked?
I asked.
Or mentioned. Yeah.
Right.
The first is the London Explorer. We've had a chance to look at that. That was a purely tort case about damage to property, and therefore is covered by the tort rule in the Sinex Ace.
Okay.
And an entirely different, we say. I mean, we might take the opportunity to write further about it, but that's all. That's the reason it seems to
Okay,
be.
well, that doesn't rule you out
No.
for your three paragraphs, possibly more, possibly four, that I've given permission for.
Just in case we forget to do them, that's the
Yeah,
submission.
fine, okay.
And the second point is liquidated damages. My
Yeah.
lord mentioned that. Of course, there are liquidated damages clause in voyage charters, well
Yeah.
known. There are well known to be no liquidated damages clause in time charters. And my learned friend's submission is that unbeknownst to 200 years worth of shipping lawyers, the usual measure of damages for redelivery, late redelivery, is in fact a liquidated damages clause. That's his submission.
Well,
Preposterous.
we said it was it gave
Nearest
the
thing.
broad equivalent, but
Yeah.
no, I understand that. Okay. I think the only point outstanding is the 8th edition of the book.
My lord, I have copies here.
Thank you very
May I
much.
hand those up?
You're happy for us to have that?
As long as
It doesn't take you by-
modesty prevents me from saying how delighted I am, but as long as Mr. Board's doing it, I'll.
You can't claim to be taken by surprise.
No.
I know that some celebrity authors probably would be taken by surprise by having the contents of their book referred to, but that's very kind.
We did invite David Williams to become a co-author, but otherwise.
No, that's very kind. Thank you very much. All right. Thank you all very much. Thank you to those sitting behind you. You'll be unsurprised to learn that we will be reserving our judgments. We found this extremely interesting and not straightforward. So we are certainly not doing anything other than reserving our judgments. As you all know, but I have to repeat in open court, once we've done our judgments, you will get them in draft. That's an opportunity for you to correct the typos and any obvious factual errors. It is not an opportunity to re-argue the case. Once you've got the drafts, you can, between you, I hope, agree what the consequential order should be. That's the principal purpose of giving you the drafts, other than the correction of the typos. You will all know as well that we guard the confidentiality of the drafts very closely. There's a warning on the front that breach of the rules in relation to that is a contempt of court. So please, it is only to go to the people on the list, which I understand has been prepared and which my clerk has. So nobody else, unless somebody applies. Once you have done the typos and once you have, I hope, agreed the order, the judgment will be handed down electronically and there's no need for attendance. If, in relation to the order, as sometimes happens, there's a point that on which you cannot agree, then the point needs to be flagged up in the draft order, perhaps 2 different versions in colour so we can see what the point is. And if that is the case, then you can provide short, and I mean short, written submissions on the particular point that is in issue between you. But other than that, that is all that we would require, and we would then consider it and formulate what the final version of the order should say. All right, thank you all very much.
All right, people.